Yeah. 3, 2.
Good afternoon and welcome to the next session of Ask Me Anything, brought to you by Horlick, Levitt, Lella. As you can see, I'm not Brian Horlick. I'm David Lella, and I'll be hosting today's AMA after what I will call considerable nagging by my good friend and partner, Brian Horlick. Now, I'm painfully aware that I have some big Brian Horlick shoes to fill today. As much as I hate to admit it, Brian is quite entertaining. So I was lamenting to my family the other day about how difficult it was going to be entertaining while talking about insurance, because those two things are generally mutually exclusive, entertaining and insurance. So my one son said to me, "Well, Dad, why don't you break the ice with some of your bad jokes?" And my other son kicked it up a notch and said, "I'll tell you what, we'll give you the jokes to tell, but there's a catch. They're going to put them in an envelope, and I can't open the envelope until I'm live on stream with you for the jokes." So of course I agreed, because I'm not that smart and I needed some material. So we're going to do it right now. I feel a little bit like the Johnny Carson letter gag. I don't know, maybe I'm dating myself. Was it not Gazoo? Karnak the Magnificent with the big hat. I don't know if anyone remembers it. Okay. So I'm not going to tell the first one. What's the difference between a lawyer and a trampoline? You take off your shoes when you jump on a trampoline. Pretty good. What's the difference between a lawyer and God? God doesn't think he's a lawyer. Brian, you're going to like this one. How does an attorney sleep? First he lies on one side, and then he lies on the other. And last, I've actually used this one before. It's a goodie. What's the difference between a vacuum cleaner and a lawyer on a motorcycle? The vacuum cleaner has the dirt bag on the inside. Okay, so thanks, guys. That was good. Good to break the ice. So now we'll get on to some less fun, but more important things. I'm going to cover a few topics today. The first one is going to be sort of a broad-based condo insurance primer. I've given my share of talks on condo insurance. I've written my share of articles. People smarter than I have done the same. But it seems like every time there's damage to a condo, there's a very considerable amount of confusion over who should pay for what, if an indemnity applies, if the deductible can be charged back, all this kind of confusion. So what I want to do partially today is give a step-by-step guide on what to do. And if you use the guide properly, you may just have to call people like myself a little bit less, which in retrospect probably isn't that smart, but I'm going to do it anyway. So I'm going to give you a typical scenario. There's a condo unit owner. Let's call him, I don't know, Brian Horlick. He falls asleep in bed while smoking after a particularly strenuous sax session. That's sax, not sex. Many of you know, and especially those of you who watch this AMA, Brian is an avid sax player. And his wife does advise me that he is tired after sax. So Brian, the unit owner, causes a fire in the bedroom when he falls asleep smoking. Smoke damages the drywall. When Toronto Fire comes, they cause water damage to the unit, the common element hallway, the unit below that unit, okay? The first thing I want you to do is have an insurance binder when things like this happen, okay? You go to your binder and you'll have some things in there that I'm going to ask you to put in. The first is the declaration, okay? But I want you to take the declaration, I want you to tab certain parts of it, okay? One is the maintenance responsibilities as they're set out in that declaration. Second is we want the indemnity provision in the declaration. Tab that, okay? That's the section that allows you to go after unit owners when they do bad things. Third, I want you to take Schedule C of the declaration and tab it. Excuse me. Schedule C is what sets out the boundaries. Okay, then from the bylaws, I want you to put a couple bylaws in that binder. One is the standard unit bylaw. Put that in there. If you don't have a standard unit bylaw, you might have that schedule that way back the developer included that set out what the different features in the unit were. If you have that, put that in there. We also want the deductible bylaw to go in there, okay? If you have a deductible bylaw. If you're trying to find the deductible bylaw, sometimes it's not a standalone bylaw. Sometimes it's in the general bylaw, so you have to look around a bit. Put that in there. So now you have all that stuff. You have your binder. So someone like Brian Horlick causes this fire with his risky sacks, and now you go grab your binder. And in that binder, I want you to have some questions that you're going to answer. Just 5-6 questions that you'll answer about what's happened. One is, what areas of the corporation have been damaged? That's far more important than who caused it and who's at fault, okay? Are they unit areas or common element areas? And you'll look at the Schedule C that's in your binder to figure that out. Who's responsible for the unit repair and who's responsible for the common element repair? Again, that's in the highlighted portion that you have in your declaration that sets out who's responsible for maintenance and repair. If unit areas were damaged in addition to common elements, okay, what is there a standard unit bylaw and what's in it? Okay. Next, how was the damage caused? Did a unit owner do it? Did one of their guests do it? Was it negligence, an act or omission? Write down how it was caused so you have that. And last, does the amount of damage justify going to your insurer in this climate of rising rates? So once you have that binder and you have those questions, you can apply it and you'll know what to do. So let's try that in our situation here. Call it the Brian Horlick risky sacks situation. The declaration in our case says maintenance and repair of the units is the unit owner's responsibility, and maintenance and repair of the common elements is the corporation's responsibility. The schedule then says that drywall and everything above the cement floor slab is part of the unit. So at first blush, it looks like Brian's responsible to repair what's in that unit, the drywall and the hardwood. Same with the unit owner below. But in your binder, you have a standard unit bylaw. So you take it out and you look at it and you say, what's in the standard unit bylaw? In this particular one, we'll say drywall is part of the standard unit, but hardwood floors are not, okay? So that means that Brian or his unit insurer, his home insurer, will have to pay for his hardwood floors, and the drywall will be fixed by the corporation's insurance, okay? If you look a bit further, you see your deductible bylaw. It doesn't require an act or omission on the part of Brian. So you can charge back Brian the lesser of the deductible and the damage done. Okay, so now you know how to approach these things. The last question is the indemnity. The corporation would love to go after Brian for damages related to his risky sacks. But remember, these are damages that are covered by the insurance. They can only seek indemnity for uncovered losses. So that leads me to the next topic, which is subrogation, because it's related. And before I dive into it, I want to play you guys one of my favorite clips. So hopefully I can do this correctly here.
So, what does being an upstairs neighbor mean to you?
It means we make sound.
People think of neighborly noise as a nuisance, but we think of it as an art form.
We want the sounds to be different, but completely unrecognizable.
It just sounds like bowling balls. That can't be what it is, but that's what it sounds like. It sounds like bowling balls.
Is it a bowling ball? Is it a metal barrel? You never know, because sometimes we get metal barrels.
You knew we were twisted, though. Julia is a fountain of creativity.
Oh.
She's a genius.
Oh.
She's so creative.
Oh.
Their ceiling is our stage, and we're dancing across it.
Yes.
It is work. You know, we often take shifts to create the illusion that nobody here sleeps.
I just want them to stop, and I want to know what the hell they're doing.
Oh, I love to feel your body all around me.
Oh, God!
See, she thinks that we're having sex, but things aren't always what they appear to be.
Oh, yeah. When we do have sex, it's actually very quiet.
It sounds like a baby the size of a giant is learning how to walk.
A floor is but a movie screen to project the mind's eye.
And all of that hard work really pays off when we get to meet our fans.
There's a lot of noise going on up here. Kind of sounds like...
Sounds tough.
Yeah. Thank you so much.
Yep. Be well.
Thank you.
You know, some people might say what we do is passive aggressive.
Thank you.
Thank you.
Okay, it doesn't matter how many times I see that clip, it always makes me laugh. Now you might be saying, Dave, what does that have to do with subrogation? You might even be saying, Dave, what the heck is subrogation? Well, remember how the corporation's insurer had to pay for the damage that Brian caused? Well, you may have noticed that insurers generally, they don't like to pay for things. I know this because I've sued a lot of them for that very reason, okay? So after they do pay, they go at great lengths to find the actual party that's at fault and sue them. So if the corporation's insurance paid out for the water damage to the common elements, they'd love to go after Brian in the shoes of the corporation for the damage that Brian caused. The same goes for that unit below, where the insurer for that unit may have paid out some money to fix some things, and they would love to go after Brian, but they can't. Now, why is that? Well, this is where the declaration comes in. The standard declaration contains a mutual waiver of subrogation. It requires all of the policies obtained by the corporation to contain waivers of subrogation against the corporation, its manager, the owners, members of their household, guests. Same with the insurance policies that the unit owners contain. They're required to contain that waiver, so you can't subrogate. Why is that? Well, people have put out the policy reason that there's a special relationship between owners and the condominium corporation. The owners, they're not simply just neighbors, they're also part owners of the condominium, and waivers of subrogation help protect that special relationship by preventing potential claims that could cause turmoil in the condominium context. So waivers of subrogation, it's all about good neighbors. That is the somewhat tenuous connection to the clip I showed about good neighbors. I really just tried to find a way to work that clip in there. Also takes up a bit of my time, which is helpful. So that leads me to my next topic, which is COVID and insurance. I would be remiss if I didn't address the COVID implications of insurance. On a personal level, I actually try my very best on a day-to-day basis to limit the amount I discuss and focus on COVID other than following what the guidelines are. We actually have a rule at our dinner table that there's no COVID discussions till dinner's over. So we cannot have that topic. It generally doesn't work. You can't really talk about anything without somehow it leading into COVID. It works its way in. So how does it work its way into insurance? There's a couple ways. The most obvious is the slew of business interruption claims that have been brought forward as a result of COVID. I can tell you most of them will not be successful because the wording of the policies generally require a covered loss, let's say something like a flood or a fire or something, that then damages the premises and prevents people from accessing the premises and getting work done. It's not just about losing money. Everybody's losing money as a result of COVID. Well, not everybody, but a lot of us are. It's a very specific coverage that emanates from an already covered loss, and a lot of it has to do with access. Now, there are endorsements on many of these policies, and the endorsements cover denied access that happens because of government orders. So, you know, in the various phases and the non-essential businesses not being able to access their premises as a result of that government order, those are situations where it could well be that the policy will cover. Okay, but they're very limited in quantum. Usually those endorsements are, the ones I've seen are all, you know, $20,000, $30,000. So most of the BI claims are not going to be successful. None of that really affects condominiums broadly. What does, however, affect condominiums is this new bill that's been introduced recently that'll provide protection against COVID-19 exposure-related lawsuits. Okay, it's called the Supporting Ontario Recovery Act 2020, and it will provide targeted, and that's important, targeted protection for those who are making an honest, also an important word there, effort to follow public health guidelines and laws. Who's going to be included? Healthcare workers and institutions, frontline workers, businesses, their employees, restaurants, retail stores, charities, nonprofit organizations, which presumably will be condo corporations as well, and volunteer organization, coaches, this type of thing. So what this law will do, it will protect anyone making an honest effort to follow the public health guidelines. It will not prevent lawsuits against those who willfully or through gross negligence endanger others. So what is gross negligence? In legal terms, it's like really negligence. No, it's reckless disregard. Okay, essentially. So if there is gross negligence, it will not apply. It is what is called a good faith immunity law. And it's welcome news to condos. It will add added protection to, let's say, the D&O policies and the protections that directors and officers get. That's going to be very helpful there. Those good faith responsibilities that they have. Also, calls are being made for federal liability insurance backstop programs for long-term care homes. So what is that? Well, obviously these long-term care homes are having difficulty getting insurance because of what's going on out there. So there's calls for this insurance backstop program. Hopefully that happens. You know, I think in general, what's gone on at the long-term care homes is sort of an indictment of our society, not just here, but all over the place. Our elderly have really suffered during this. So I'm hopeful this comes through. This will be welcome. And this insurance backstop program for care homes, it reminds me of issues that we're having with condo insurance and the rising rates. Okay, I talked about this not that long ago. It was just prior to COVID, I guess. Maybe it was the ACMO lunch before COVID hit. I think it was in February. We talked about how we're seeing premiums increase sometimes in the 600 to 700% range. Craziness, okay? A 26-story condominium in Abbotsford, BC had an astronomical 780% increase to their insurance premiums. So the annual rate jumped from $66,000 in 2019 to a mind-boggling $588,000 in 2020. The deductible situation. The deductible situation is just as bad. I've seen water deductibles go from $10,000 to $100,000, from $100,000 to $200,000. A modern condo building, again in Vancouver, there will be a lot of problems out that way. I know of having a water deductible of $750,000. Okay, so with deductibles that high, can you imagine as a unit owner being deemed responsible for a loss and having a deductible chargeback where there's a no-fault deductible in place? That would be absolute devastation for a family. They probably have to sell their condo. I know there's a government commission report out that way in BC, the Financial Services Authority. They said the insurance market there is not healthy for about 1.5 million people in condos and townhomes. No kidding. So what's being done? We talked about how the IBC hired a risk manager to work with corporations so they can better understand the risks and how to manage those risks, okay? We talked about how they're in talks with insurance companies and the government over condo insurance. I know also legislation's just been introduced out west, which is trying to address the skyrocketing prices. The first part of it, I think, is it's addressing referral fees. So referral fees that insurance companies pay, I guess, brokers and others that send them the business, they're paying upward of 30% for these referral fees. And that's, of course, driving up the cost of these policies. So that legislation is apparently tackling that first, and there'll be other things to come. So that's an ongoing problem, and something you have to keep in mind, too, when you are addressing an issue in your condo and thinking about, am I going to put this through insurance? You really have to think about, what's the deductible? Am I going to be able to get that deductible back from the unit owner? And what's this going to do to my premiums? And those are conversations you should be having, not necessarily with your lawyer, because we're not the best resource for that, but with your broker, okay? So keep that stuff in mind. I also wanted to talk a little bit about construction deficiencies today, and Tarion. Tarion's really a form of insurance. Before I do, I'm looking at this screen here. It's like another Zoom type engagement that I'm doing, and I'm sure you're all doing the same thing constantly. So it's like all day we're on our computers with this little corner up there of our face. Used to be, you'd get up in the morning, you'd brush your teeth, you'd see yourself. You'd go to bed, you'd see yourself. Now it's all day. And what my son said to me the other day, we were looking through some old pictures and things, trying to find something to do. And he said, "Dad, well, you've had a real glow down." And I was pretty sure I knew what that was, but I looked it up anyways. So I went to the Urban Dictionary to see what glow down was. So here's what it says. The opposite of glow up, used to describe someone who used to be attractive and has with age actually decreased in attractiveness. Quote, "Damn, did you see Doug's latest Instagram? He gained like 20 pounds. Yeah, the glow down is real." That's what it says in the Urban Dictionary. So now we get to watch our daily glow down constantly as we're on these screens. And glow down is like a deficiency. So that's my lead into construction deficiencies. Couple things on that front. At a recent-ish Case Law Corner, I discussed York Region Standard Condominium Corporation 1206 versus 520 Steels Developments Inc. That's a mouthful. Two things came out of that decision. I'm going to just briefly mention them here. If you want details on it, go to our case law corners and take a look at it. But first, we all know that when you start a lawsuit as a condominium corporation, you send out notice to the owners under Section 23 of the Act. After this case, if that is forgotten, if you don't do that, if your lawyer doesn't do that, the case is no longer a nullity. So that's good news. Okay, people can breathe a little bit easier. Second, if you have a construction deficiency claim and you sue not only the declarant, but you also sue the developer, okay, that will likely survive a motion to dismiss by the developer. You see, what they would do in the past is, if you sued the declarant and the developer would say, well, hey, there's no privity of contract. Unit owners didn't contract with me. The corporation didn't contract with me. What are you suing me for? I'm nothing here. You have a declarant. But of course, you know, the declarant's a numbered company, and you want to bring that developer in if you can. And the developer in that particular case tried to bring a motion to dismiss on the basis that there was no privity. Courts are going to look closely at what the developer's role is, how it overlaps with the declarant, who's wearing what hats when. So that was also an important development. Mainly because, as you can guess, declarants oftentimes don't have assets. The worst thing you can do, the worst, is pay your lawyer a bunch of money and get a judgment, and then you have to just hang it on your wall because you can't get any money for that judgment. You want to be able to collect. So that's where you try to bring what a lawyer I used to work for called the shotgun approach. Bring everyone to the table. This is a good way to do it. Of course, do that in consultation with your lawyer, because there can be cost consequences if you bring in people that shouldn't be there. But that's a good development. Speaking of shell companies with no assets, that's actually the exact reason why we have Terion, right? And the warranty process. So there's been some developments there. October of last year, the Ontario Auditor General completed their audit of Terion. Here's what they said. The current system administered by Terion does not properly protect the interests of new home buyers and condominium corporations in Ontario. Another shocker. Not so shocking to those of us that have been involved in the process. This followed the detailed review of the Terion process that was conducted by Justice Cunningham, and that was back in 2016 or 2017. So now we actually have the passing of something called the Rebuilding Consumer Confidence legislation that happened over the summer, and Terion is moving forward with some change. If you've been involved in a Terion process before, you know that it's all encapsulated in something called Builder Bulletin 49. If you want to know what the timelines are and what to do and how it's going to work and all this kind of stuff, if you just go online and pull down Builder Bulletin 49 from Terion, it's all there. It's great. And a new bulletin was issued in September 2020, and Terion says the following about this bulletin. This bulletin introduces a formal process for making common element warranty claims. It sets a customer service standard with clear timelines to address issues and minimize the time and effort it takes for builders and condo corporations to resolve claims. Not today, but I am going to go through that bulletin and the Rebuilding the Consumer Confidence legislation, do a paper, put it up on the HLD resource page. You can take a look at that, see where that's going. This is all in its infancy, but it's welcome change. Anytime we can improve the experience for the consumer, for condo corporations, going through that Terry-on process, it's a good thing to do. Having said that, you know, the warranties remain the same. 1 year is the construction in a workmanlike manner, free from defects, fit for habitation, building code. Second year looks at water penetration, defects in materials. You have the structural warranty that's 7 years, okay? That stuff's all the same. One thing I will say, just in general about construction defect issues, if you're going through them, if you're managing that process, keep in mind that just because you're in the Terry-on process, the clock on a lawsuit doesn't necessarily stop ticking. So when you bring an action in Ontario, you have to bring it 2 years generally from the time period that you knew you had a claim, that you should bring a claim forward. There's exceptions and there's Limitation Act and that, but generally that's the case. That's generally what applies to condominium corporations. And again, generally speaking, the corporation knows about an issue when they have their first year performance on it. So 2 years from that date, if the issue's in there, you should likely bring it forward in a lawsuit. Even if Terry-on is still going forward, okay? You need to protect that. You can have it, you can talk to your lawyer, you can give me a call, you can have it sit there, not serve it for a little bit. You can enter into agreements to toll the limitation period, okay? Tolling agreements. You can enter into those as well. There's different things you can do, but you've got to protect yourself, okay? That's important. Another important point there, you can't sue engineers, architects, or anyone other than the builder when you're at Terry-on. That's another reason sometimes why you bring an action as opposed to Terry-on. So that is the completion of the topics that I'm going to talk about. But maybe there's some questions, and we can get to those now. It looks like there are some questions. Hilarious neighbors from hell. Yes. Again, it's like sometimes I just watch it when I need a little pick me up. Love the clip, and so appropriate in the condo world. That's Olivia. Thank you, Olivia. Leo. A unit owner had minor water damage to carpeted standard unit. Owner cut section of carpet to investigate water leak before management investigates the water leak. Also from Leo, owner removes the carpet and installs laminated floor and now wants to charge back the owner who caused the water damage for the cost of the carpet that he removed. No, that's not how it works, okay? The way it works is wherever the damage is, wherever that location is, you look at who's responsible for what. So that unit owner who's downstairs who had the damage, if he's responsible for the floor coverings, then he's responsible for the floor coverings. And if that's part of the standard unit, then the condo has to pay for that, okay? Subrogation is prohibited if you're an insurer. It is possible if a unit owner in a condo has damage caused by another unit owner and they properly have to pay for it, not the condo. It's possible they can sue because that's not subrogation. But let's say in that situation, Leo, that unit owner, their insurer came in and fixed some things that they were supposed to fix. They would not be able to subrogate against that upstairs neighbor, okay? Olivia, with the current pandemic, how will it impact the premiums in the condo industry? Well, you know, your car insurance is going down. That's good. In the condo world, I don't know. We're going to have to wait and see. I don't see it having a significant impact on the condo world because really The most significant thing going on in the condo world with insurance is water. Water is the new fire, okay? That's what they say. We have these vertical cities, and water causes a tremendous amount of damage. When I was a kid, you turn on, I don't know if anybody remembers Eyewitness News with Irv Weinstein, and it was like Buffalo was always burning, right? Lackawanna, Tonawanda, North Tonawanda, everything was made of wood and it was all burning. And insurance policies used to be called fire policies, and they eventually morphed into these all risk policies. But water's the issue. So we'll have to wait and see how this pandemic affects condo insurance. Eleanor, in the absence of a standard unit bylaw, how does the developer standard features list play into covering damage to a unit caused by the corporation? Hardwood flooring comes to mind. So you just kind of use it. You use that standard features list as if it was the standard unit bylaw. And so then if hardwood is one of the features on that list, you just to say to yourself, okay, that's part of the standard unit. The corporation's insurance is responsible for paying for that. So it's just a stand-in if you have it. A lot of times people don't have that feature sheet anymore. It's for the older condos. Should the manager attempt to avoid the corporation's responsibility to repair improvements? Well, look, this is where you go through that binder and see what you're responsible for and what you're not, okay? If the unit owner is responsible to repair the unit, then he's responsible to repair the unit, subject to what's in the standard unit bylaw. Whatever's not in the standard unit bylaw is the improvements, okay? Let's see, Bruna. A drain pipe leaks on the top of an owner's car in the garage. Should the corporation pay to repair or clean the damage to the car? That's an interesting one. The car has insurance for that kind of damage as well, but then of course there's a deductible. So they could put it through their car insurance, but I suppose the issue would be the unit owner would say, well, I've got this deductible I've got to pay, and it's not my fault, it's your fault. And then the situation, I guess, becomes, was there a maintenance responsibility that wasn't met? And if it wasn't, then that goes under a different part of the policy. It goes under the liability part of the policy that the corporation has, not the property damage portion. Olivia, thanks. You are welcome. Let's see. Anything else out there? Any more questions? Doesn't look like it. Okay. Nothing pops up in the next couple of seconds. We'll sign off, and everybody have a great week. And please visit our case law corners, see what's there, and we'll see you for the next AMA. Bye-bye. I'll leave you with the video.
So, what does being an upstairs neighbor mean to you?
It means we make sound.
People think of neighborly noise as a nuisance, but we think of it as an art form.
We want the sounds to be different, but completely unrecognizable.
It just sounds like bowling balls. That can't be what it is, but that's what it sounds like. It sounds like bowling balls.
Is it a bowling ball? Is it a metal barrel? You never know, because sometimes we get metal barrels.
You knew we were twisted, though. Julia is a fountain of creativity.
Oh.
She's a genius.
Oh.
She's so creative.
Oh.
Their ceiling is our stage, and we're dancing across it.
Yes.
It is work. You know, we often take shifts to create the illusion that nobody here sleeps.
they're doing.
I love to feel your body all around me. Oh.
See, she thinks that we're having sex, but things aren't always what they appear to be.
Oh, yeah. When we do have sex, it's actually very quiet.
It sounds like a baby the size of a giant is learning how to walk.
A floor is but a movie screen to project the mind's eye.
And all of that hard work really pays off when we get to meet our fans.
There's a lot of noise going on up here. It kind of sounds like...
Sounds tough.
Yeah, thank
Yeah.
you so much.
Yep. Be well.
Thank you.
You know, some people might say what we do is passive aggressive.
Thank you.
Thank you.